Welcome to LAW2020 Online. Practice Management Shaped the Debate with me, Emma Dion from the Solicitors Group, and our expert speaker, Trevor Hellawell. In this live session, you can put your questions to Trevor and interact as the information is being delivered. Today's live Q&A is due to last an hour and will cover pre-submitted and live questions. On the right-hand side, there's a chat function. All the questions are submitted in private, so please do ask away. Don't be shy and get your questions into Trevor. If you're watching a replay, the live chat function is disabled, but you may contact the Solicitors Group for further information. A recording of today's live session will be sent out by email within 48 hours, so please keep an eye out for it. So if I can introduce Trevor Hellawell. Since training at Cambridge and the College of Law, Trevor has spent the bulk of his professional career on the training and consultancy circuit, mainly now in the compliance sphere, talking about standards and regulations, professional ethics, anti-money laundering, cybercrime, the accounts rules, and GDPR. Trevor also has a history in the litigation, property, insolvency and environmental sectors and wrote the Law Society's Environmental Law Handbook, which ran to 7 editions. As part of LAW2020 Online, Trevor's sessions included oversight of client money and assets post-COVID, cybercrime on the surge, client care correspondence, can we do less, and the new normal, the regulators' expectations post-COVID. So, to kick off, we'll start addressing some of the pre-submitted questions we've been receiving from you. First one, Trevor. How can you deal with fake or incorrect date of birth and names on identity documents, such as on passports and driving licenses?
Thanks, Emma. The first thing I want to say is I do apologise for this. I don't normally have a bruise on my forehead. There are reasons for it. I think the sort of politest way of putting it is I was going to a fancy dress party as Mikhail Gorbachev, and I just got it in the wrong place. So apologies for that. But the other point I'll make is that as Emma has already said, I do talk about money laundering, and this first question is about money laundering and in particular CDD processes. It says, how can we deal with fake or incorrect dates of birth and names on identity documents? And there's a distinction to make between incorrect information, which could just be due to the client's ineptitude. He sends us a letter and transposes 2 numbers and all that kind of stuff. And that just needs to be clarified with the client. If you do an electronic search or you do a search of the passport agency and it just comes back not matching, that could just be an error and that could be easily corrected with the client. If for some reason it doesn't get corrected, then I think your curiosity should turn to concern, and you should be putting the client on notice that, well, hang on, unless I get the correct information, I'm not going to be able to act for you, or something of that nature. But incorrect information, I think, is relatively easy to fix. The more insidious question is, what about fake information, and in particular fraudulently obtained but genuine documentation? This is a real evil, I think, as far as the lawyers are concerned. It says in the Legal Sector Affinity Group guidance note that other than obvious forgeries, we're not expected to be an expert in forged documents. So forged documents, fake documents, or fraudulently obtained but genuine documents are a problem. And I don't honestly think there is a lot we can do about it. And I often say when I'm talking about this that, you know, if you imagine that there's an organised criminal gang out there that was determined to use your law firm as a front for their illegal money movements, they will come prepared with fake documents, cloned driving licenses, genuine bank accounts that have been bought from some deceased client, something of that nature. They will come prepared. And they will be far cleverer than any of we will be, and I don't think that we will be able to spot the fraud. So I think it's a case of us doing our level best with the information that is given to us. But that's all our duty is. Having said that, I would also say that the key to good money laundering adherence is not only customer due diligence, which obviously has to be done properly, has to be done sensibly, has to be done diligently, has to be done fully, and all the rest of it. It's the other duty, that of ongoing monitoring, which I think is actually the more important. And I think this is about the only way we might spot those who are trying to fake their way into our client bases. They get through the CDD system with the fake and fraudulent documentation, and they might even take us through a series of perfectly legal transactions. But what we ought to be doing at every stage in the game is the duty of ongoing monitoring, which is actually in paragraph 28(11) of the regulations. And it says that we must also undertake a scrutiny of the transactions undertaken throughout the business relationship to ensure that they are consistent with what we think we know about the client, his business and risk profile. And I think if we're doing that bit of our job, then the chances are that we might unravel something that turns out to be crooked. Because on a worst case scenario, a client infiltrates our systems, takes us through a series of transactions, all of which are perfectly legal and straightforward, in the hope that they've lulled us into a false sense of security. And when they think we've stopped looking, they'll shaft us with the bad one. And if we're undertaking this sort of ongoing monitoring job, then every time we're instructed on a new matter, we should be investigating to see if it's consistent. And the chances are that there will be something about the fraudulent transaction which is inconsistent with what we've done before. And that we have to pick up on that and ask about it. And the chances are the client will say, oh, yeah, I'll have to give you a ring back on that. And he'll hang up and he'll disappear. And that's what will unravel them, not the CDD process. So I think the short answer is incorrect stuff we obviously need to correct if we can. Fake stuff, I think we just have to, other than obvious forgeries, just have to do our job. If it looks fine, we can assume it is, but we have to keep an eye on what we are then instructed to do for the clients as much as who the client says he is.
Yeah, so it's really sort of ongoing monitoring and ongoing vigilance, really.
Completely. I mean, I often say, you know, just as a sort of throwaway summary, that really what money laundering law is it's a culture of constant vigilance. And that's it. You know, as there's all the stuff and the guff about the customer due diligence thing, which takes 95.5 pages of the regulations to deal with. But actually, it's not the most important point. And those 3 lines about ongoing monitoring, I think, are by far more important. And that's it. It's a culture of constant vigilance. It's not something that we can do to the clients at the start of a matter and then forget about it.
Yeah. Okay, great. Thank you. Next question. So are you saying that we can contract out of paying interest to clients on monies that we hold for them? I thought the SRA said that was not allowed. So that's a question for you.
Yeah, this is obviously about the accounts rules, and it's obviously about the provisions in the accounts rules in Rule 7 that talk about the payment of interest to clients on client balances, which they leave with us for any number of reasons. The position has long since been that, well, in the old accounts rules, it used to say if you have more than £1,000 for more than a week, you owe interest and all that kind of stuff. And that was all done away with back in 2007, and it was replaced with our obligation to have a policy on the payment of interest. Now, what Rule 7 now says in paragraph 7.1 is that we still are under an obligation to pay a sum in lieu of interest to clients on their balances. And that's fine, I accept that. But it then says in paragraph 7.2, unless you come to some other different arrangement with the client as to the payment of interest. Now then, this interested me because it's long been a faff for law firms, I appreciate, to calculate you know, how much interest is owed on this balance and that balance and this, that, and we get to a sum total of £12.48 that we owe to the clients. And we may well have a policy which says we'll only pay interest if the sum due is more than £20 or something of that nature, all of which is perfectly okay. But it's a real drag. And I saw in paragraph 7.2 an opportunity to just say to clients right at the start of a retainer that under normal circumstances, we do not propose to pay interest on client balances. As long as we've given the client written notice and sufficient information to enable them to make informed decisions, it would seem that we can include such a term in our terms and conditions. And I've been saying this for a while, and I'm not the only one to say it. Several accountants have made the same comment, and other sort of famous commentators have made similar comments. And then I was sort of hauled up by the SRA, and I ended up having a bit of correspondence with them. And they were saying, oh, no, it's not right that you can contract out of it. It says in 7.1 that you still owe them a duty to pay them. And I said, yes, but it says in Rule 7.2, unless you come to some other arrangement. Anyway, this conversation never quite got resolved, but I stand by the view that it would be possible for us to say to clients, under normal circumstances, we do not propose to pay interest to you on client balances. If you're not happy with that, then please contact us, and obviously we can come to some different arrangement. I am also, of course, conscious that for substantial sums of money, expectations would be that it would be a different position. Lengthy periods of retention, private client administrations, things of that nature, again, a different expectation might arise in the minds of the client. So you could put something into your terms and conditions along the lines that sums held for over 6 weeks have a different feeling to them. Sums in excess of 250,000 may have a different rule applicable to them. But broadly, as a firm, we do not propose to pay interest. I still think that that is a defensible position. I mean, the other option is that we put our de minimis threshold at 50 quid or something similar, which would, the current interest rates require us to hold substantial sums of money for substantial periods of time before we got anywhere near 50 quid's worth of interest. So, realistically, there's just no interest being paid. There's a number of ways around it. But I just feel that the rules are slightly more flexible now than they used to be. So I still think it is possible for us not to contract out of it necessarily, but to put terms in place which would relieve us of the necessity to pay small sums to miscellaneous clients on smaller balances. And I honestly do think that the SRA's rules permit that now.
Okay.
Just one other thought on interest. I mean, obviously the whisper at the moment is that what do we do if interest rates go negative? And in my 62 years, I've sort of I don't think I've ever known negative interest rates. So I'm trying to get my head around it. But the idea is that if we, as a law firm, bank with Barclays or whoever it might be, and we end up getting charged by the bank to leave money with them, then I think we ought to reserve our rights to charge the clients a sum for leaving money with us. And in fact, this morning, actually, I was reading somewhere on the blogosphere that commentators are suggesting that maybe firms want to rewrite their terms of business to include something along the lines, in the event that interest rates become negative, we reserve the right to charge you interest if you leave monies with us. And obviously, we'll discuss this with you should this ever arise. And my own sort of take on this is, if we're not paying interest, I don't think we can charge interest, if you see what I'm saying. if we do pay interest, then I think it's only fair that we charge interest. So I think it's a quid pro quo. And I think overall, we have to treat the client fairly and sensibly, as of course we always have. And I just don't think it would be right to charge them interest if we're not going to pay it.
Yeah.
So I think it's a case of each firm is free to do its own thing. But yeah, in short, I think, yes, we are able to just contract out of those gawpy calculations that we've had to do all these years.
Yeah, but perhaps one to look out for if negative interest.
Well, I know. I mean, the whole thing just goes off piste if it goes into negative interest rates. I mean, everybody will just be stuffing their money in the mattress. Which actually I think is the best pensions advice you can get. Actually, I think if any of the benchmarks that I've been looking at are to be believed, it's the best thing you can do with your money. Stick it in your mattress and have done with it. But anyway, that was a joke, by the way.
Right, we've had a delegate's question. So do you think that taking clients' photographs would be a useful tool to employ in dissuading fraudsters?
Yes, I think I do. I always say when talking about money laundering that, whatever paperwork you get through, you need to see the clients. I mean, I can see your face now, and I presume that you're the MD on that I was talking to last week. And that's fine. I can see that. And if need be, you could hold your passport up and I could compare the two. And increasing the online search providers under the pressure of the money laundering regs have to give us the reassurances that we're seeking, that the people claiming an identity are in fact those individuals. And they can only do that through facial recognition technology, biometric technology, or some kind of facial visual recognition. So I think it's coming. And I think in the shorter term, the point about having a photograph or taking a photograph of a client is the best way forward. Because apart from anything else, if they're talking about taking a screenshot of a Zoom call or something of that nature, then there's all other kinds of things that you can look at. You can look at the background, you can look at the house, you can sort of, see all kinds of things. I mean, it's almost like I'm looking at you across the desk. Which I can't get from any other mechanism. And if you wanted then to take a photograph of it just for the record, then I think, yes, fine. And I think, yes, it would put the fraudsters off. What I find myself saying is that if they're a crook, they will find ways of avoiding that because they don't want to have their face spread all over the place. So, I think, yes, it is a very good ploy.
Good, great. Okay, thank you. Next question. Do you think that now we are looking at a second national lockdown, the SRA will adopt the same regulatory forbearance they've shown in the first one?
Let's hope so. I mean, obviously, we're looking at a national lockdown from Thursday for a month at least, according to Michael Gove. Could well be extended. Let me just sort of give a bit of background. When the first lockdown happened, the Chancellor, in his first announcement, I think, mentioned the phrase regulatory forbearance, which I thought, yes, good, fine, thank you. The pressure's off. And to some extent, for the next 6 months, it was off. In that, we were all at home and it was all new and all the rest of it. And I think the SRA were taking the pragmatic view that if you did things that were technically outside the rules, just make a note of what you've done, make a note of the reasons why you've done it. And if there were any complaints, but it was clearly attributable to COVID considerations, then they would probably take no action. Which I think is the kind of regulatory forbearance which I think we might expect again. Having said that, the reason I hesitate is that this is the second lockdown and it is different from the first. We are still working, albeit remotely, which we've been doing for many months. And undoubtedly the SRA's take is the rules are still the rules. And despite the awkwardnesses of working from home and remoteness and the supervisory sort of finesses and all the rest of it that come with it, the rules are still the rules. However, I think they will, much as they've done with the furlough scheme, is they will extend whatever forbearances they were demonstrating for another month. But we'll then be at the end of 2020. It'll be 3.5 years since the money laundering regulations came into place. They've already been, well, they've been conducting a check on all of us for the last year, really, on how we've got to grips with the risk assessments and all that kind of stuff. They're now asking questions about what questions are we posing about source of wealth and source of funds and all the rest of it. And I honestly don't think that they're going to stop that series of queries. So I think, I mean, I'm speaking for the SRA here, and obviously I'm not employed by them, but I would be inclined to think that if there are, I was going to say errors, that's not the right phrase. If there are adjustments to our systems and processes that we've put in place, and they are directly attributable to the COVID restrictions, I don't think any action will be taken against us. What none of us can do is use COVID as an excuse for not complying with the rules that we should have been complying with.
Yeah. Okay, great. That was really, really helpful. So another question from a delegate.
Yeah.
Should we insist on clients sending copies of proof of address they've received via post? A number of clients only have online statements available, which could be tampered with.
True. I go back to what I was saying in answer to the first question, and that is that the customer due diligence infrastructure is not actually as infallible as we might like it to be. The whole name and address and date of birth information, we've got to get in, we've got to get it in the best form. And obviously we need to be checking it as well to see what it is actually telling us, because there've been several cases where addresses have been sent to us that weren't on the registered proprietorship register, weren't registered with the land registry as alternative addresses, you know, so where the hell were these people, you know, and nobody asked that question. So yes, all of that has got to be done. Having said that, I find it difficult to get excited as to whether or not it comes in by post in hard copy form or whether it's an electronic information. It's the same with bank statements. You know, bank statements, you know, should be the original bank statement rather than an online copy. But not everybody gets written statements these days. You know, often they can only get online copies. And I find it difficult to get upset about one form or the other, frankly, because of the point I was making earlier on. If it's fake, it's fake. And whether it's in paper form or electronic form, it's going to make no difference. What will make a difference is the vigilance that we talked about earlier. And if people are doing that bit of their duty seriously, the chances are they will pick something up that is out of kilter with the statements in whatever form they've come in, and so on and so forth. So I think it's the other thing I'm always careful about is I don't want to start saying, oh, it's got to be in paper form, it's got to be within the last 6 months and all the rest of it, because that just creates problems and it just gets in the way of doing business. And I don't think the money laundering regulations are intended as a business prevention exercise. It's a case of do the best you can, you know, make a judgment on what you're told, but then never take your eye off the ball. You know, just view everything with inherent skepticism. Don't trust anything that you're told at face value, but just investigate and ask. And, you know, if you're given a rational explanation, get on with it. And that is about the sort of fair way through. And I honestly don't think the method it comes in, whether it's a copy through the post or an electronic copy, would really make that much difference. Okay, great. I think that will really really help our delegates. Thank you for that. Next question, on undertakings, is it true that they are worthless now? Well, none of these questions are easy, are they? Undertakings. They are the oil in the machine of the legal system. You know, they help the machine tick over. We'd be stuck without them and all the rest of it. So I hesitate to say that they are worthless now. Having said that, I have heard on the grapevine that SRA people sort of take the view that they're hardly worth the paper they're written on, or if they're verbal, they're not worth the words, and they're not going to enforce them anyway, and all that kind of stuff. I hope that is not true. I would say the position on undertakings is pretty much as it always has been. An undertaking is just a statement that you'll do something, and the expectation is that as a professional you will do it. You know, your word is your bond. If you cannot trust your lawyers to do what they say they will do, well, we may as well all pack up and go home. So yes, it is still true that we have to do what we say we will do, and I think that is true whatever form of words we give it in, whether we call it an undertaking, whether it's formal, whether it's a smiley face at the end of an email. You know, I just don't think it really matters. It's a statement that the recipient reads as our promise to do something, in which case we've got to do it. So I don't think they're worthless. Where I think there is some ambiguity is in the recent dissembling of the profession that we had with the introduction of the standards and regulations last November. Because there, of course, the freedoms for non-regulated entities to deliver legal services to the general public was generated. The facility for me as a lawyer to be engaged by those unregulated businesses and deliver legal services to the general public was also envisaged. And this was a novelty. And I think the effect of that is not to undermine the undertaking given by the legal services firm, but I think it undermines undertakings given by these non-regulated entities. Because if I were undertaking a conveyancing procedure on behalf of an SRA regulated entity with a non-regulated third party, but they employed a solicitor, and that solicitor gave me undertakings as part of the conveyancing process that they would discharge charges and all the rest of it, would I accept that undertaking? Because effectively, it's a personal promise by that individual lawyer that he will pay these things off. His employer won't have to step into the way of the bullet in the way that mine would. If I give an undertaking and I fail to honour it, the law firm will step in and have to pay. And that, I think, is what gives it the value. It's not so much the promise, it's the financial worth of the person giving it. So I think there are circumstances now, since the introduction of STARS, where I think we have to ask, well, look, who is actually giving this undertaking? And am I going to rely on it if the only person who is ultimately responsible is an individual who hasn't got the means to pay if it should all go horribly wrong? So I think from that point of view, it's not that undertakings are worthless. Clearly they're not. They're valuable. But I think whether we rely on them, I think has to become a matter of a good deal more caution than perhaps used to be the case.
Yeah. Okay, great. Thank you. No problem. Another question to tax you. We have a client who is wanting to gift substantial sums to his daughter before the stamp duty holiday comes to an end in March next year. He's worried that due to the size of the gift, in excess of 300,000, AML procedures will get in the way and delay things. What do you think?
So it was a parent wanting to give money to his daughter.
Yes.
Ostensibly to allow her to buy property before, in time before the stamp duty holiday ends. Yeah. I don't think there should be a problem on the assumption that the money was legitimately earned. it's been legitimately retained, it's in a genuine UK bank account. I say UK bank account, it doesn't really have to be. And there's a clear transmission to the daughter, normal gift from bank of mum and dad, etc., etc. I don't think there should be a problem. Having said that, 300 grand is a lot of money, and it just raises a few red flags. So, I mean, yes, inevitably, I think there will be questions asked. Whether it would delay things, I think, is a moot point. I mean, I often say in money laundering discussions, it doesn't matter how big the sum is, it's how it was generated that's important. It doesn't matter whether it's in cash. It doesn't matter whether it's in a Tesco's 5p, bag for life. It just doesn't matter. It's how it was generated that's important. Money coming through the banking system, as we all well know from the FinCEN revelations, it could well be as bent as anything. So the method of its transmission shouldn't really matter, nor should its size. What is critical is how it was generated and where it's been kept. So I think what I would be suggesting to this client is that he needs to anticipate the questions. And I think he needs to, and his daughter, need to come prepared with their full ID evidence, so there's absolutely no question about who they are. And he can give a legitimate explanation as to where the money's come from, how he's accumulated it, and so on. He could perhaps come up with a load of bank statements if he wanted to. And the agreement with his daughter as to the transfer and whether he wants an interest in the property and all that kind of stuff. Anticipate all of those problems before he goes to the lawyers, because that will just answer then any questions that the lawyers might have. Because that's what I would be asking. Well, where's this come from? How have you generated that? Oh, I see. You've got all the information here. Okay, well, fine. Fair enough. Let's go ahead then. It's like anything. It's know your client. If you know your client and it all sounds plausible for what your client does, fine, get on with it. There's no need to dig for dirt that may well not be there. So I think as long as he can prove there is no dirt there, then that should be absolutely fine. And I think that will speed the thing through insofar as is possible. Yeah.
Okay. Great. So. Still on the AML, next question is, can we use electronic AML searches now? I heard that the AML regs permit that now.
Yes, we can. I mean, obviously, we've been using electronic search tools for some time, but I think in the early days, there was a tendency to use them in addition to the standard, passport and utility bill type of name and address mechanisms that we were using anyway. We might just add an electronic search in as well as an enhanced CDD if we needed, just to reassure ourselves. The 2017 regulations, as amended by the 2019 regulations, which came into force in January of this year, January 2020, says that we can trust electronic searches as being genuine and reliable and independent sources of information, provided they do two things. Provided they can reassure us that they're free from fraud and misuse, and they can give us a reasonable assurance that the person claiming a particular identity is in fact that person. And that's where electronic search provision has tended to be weak, because what they've done is they've just taken information that we provide, they plug it into a set of searches. They'll check the passport office, check the electoral roll register, they'll check PEPs and lists if there are such things, they'll check sanctions lists probably, and come back with a negative answer. You'll get a green tick and therefore you'll get on with the job. But nowhere does that prove that you are in fact Emma Dion, and that's the bit which they're now having to provide us with reassurance on, that they are now able to say that we've checked her out and she looks like the person who's in the photograph. So insofar as we can do that, then we are giving you all the assurances that you need. And increasingly, the search providers have given us those reassurances. And as I mentioned earlier, they're using biometric technology, they're using facial recognition technology, they're using all kinds of new technologies to give us those reassurances so that we could rely on them to the exclusion of the older and more tedious and more time-consuming methods of getting two documents in and copying them and then sending them back to the clients and all the rest of it, which is, I mean, it's not necessarily inconvenient, but it's more cumbersome, certainly. Yeah. So we can use electronic searches, and on one point in particular, I think we can use them, and that's the PEPs search, because if the client is a PEP, we need to know that, because we need to undertake enhanced CDD and take extra steps to just ensure that we're okay in acting for them. And I've often said, how would you ever know you're acting for a PEP unless you ask? Emma Dion from the pie shop down the road, how would you know that, you're the great granddaughter of F.W. de Klerk, the former president of South Africa, but if you are, I don't know whether you are, but if you are, then I need to know that. You married Adrian Dion, so surname's no indicator, but I need to know that, and therefore I would suggest that there are two ways of checking this. You either do an electronic search, or you put a form in front of the client which says, look, have you ever been the daughter of the former South African leader? No, of course I haven't. It's so ridiculous. But even that sort of form-filling idea has had cold water poured on it by the SRA, who say, well, what if the client lies? Say, if the client lies, our bets are off anyway. But, the only surefire way of testing it, and even this isn't guaranteed, is to do an electronic search. So I think, realistically, the mood music is coming around to the idea that e-searches are the way forward. Yeah. And particularly because we can always charge the client for doing it. This is another debate which is ongoing, because people, oh no, we can't charge the client for that. It's part of our overheads. No, your overhead is you're considering the results. The actual search you can charge as an expense. And as long as you make it plain to the clients at the start of the matter that it will be included in your bill, there's nothing stopping you charging the 6 or 10 quid a head that it costs. So, I don't think there's any cost excuse for not undertaking an electronic search, and I would be inclined to be doing it in any event, I think, for that reason. Yeah.
Okay, great. So we've got another delegate question in. Can we take deposits for clients, i.e. for £1,000 to start a matter before the client has had a conflict check and AML search?
This is a tricky one, because this is, of course, common practice. You're instructed on a conveyancing matter, you ask them for a deposit comes in, and you're still busy chuntering on with all of the rest of the stuff. I'll try and talk my way to a conclusion, if that isn't a confusing way of doing it. Ideally, the position is that we should do conflict searches and have completed our AML searches before we enter into any banking transaction with a client. So I think ideally we shouldn't be taking money from people until we have done all of the conflict checks and done an electronic AML search or whatever else it might be, which may take only minutes to do. But whatever systems we have in place, we ought to have completed them before we undertake a banking transaction. Having said that, that's not the way of the world. And we, of course, take a deposit of £1,000. It comes into our client account whenever the clients send it. Two things then will happen. Either we've opened a client matter, in which case it can be posted on that client matter, or it'll just be held in a suspense ledger until such time as we have completed matters. Let's say we then open the matter and we can then allocate the money to the properly numbered matter. The other thing I'm thinking about is this client money or is it our money? It is client money if we haven't billed it and we haven't yet spent it. So I think it would go into client account, logically, because we haven't spent the money on searches yet and we haven't billed for it yet either. If we had billed for the money, so taking the deposit but against a bill that we send to the client, it can be ours and it can be banked into Office straight away if that's our preference. So there are a sort of number of cash flow issues that I think need to be thought about in actually where we put this money in order then to be able to spend it. And I would be inclined to say if it isn't billed and it hasn't been spent yet, it goes into client in the same old way. Obviously, the problem comes if we've received £1,000, it's held on suspense ledger, we do an AML search and it comes back negative. You know, it just doesn't match. What do we do then? If we decide not to act for the client, then I think we are obliged to return the monies to the client unless we have some genuine reason for suspicion that they are bent and crooks and we're going to report it to the National Crime Agency, in which case returning it to the client may well be a criminal offence. So I think, you know, it's awkward. And I think the counsel of perfection is that we shouldn't be accepting it. But of course we will. What I would, I think, want to be doing is minimising the delay between the receipt of the monies and the completion of the various searches. And I would just keep it on a suspense ledger pending the day or two that we're doing the searches before we make the decision that, yes, we're going to act for them, in which case it gets transferred to the client account. So I think, you know, the reality and the regulations don't always go hand in hand here. But I think, to be honest, yeah, I would do it, but I would be getting on with these other things as quickly as possible in the meantime.
Yeah, don't delay on those checks.
Exactly, exactly. It just creates problems for yourself. Yeah.
Okay, next question. Well, we're firing at you thick and fast this afternoon, aren't we? Must we be charging VAT on all our disbursements now after the Brabner's case?
No. I say that because disbursements are vatable or not vatable depending upon the VAT status of the person supplying the goods or services. We should be charging VAT on all our expenses, which are all the things that we buy in to enable us to deliver our services to the client better. I'm thinking of conveyancing searches. I'm thinking of, and incidentally, they've just withdrawn the postal concession for conveyancing searches this morning as well. So there's no difference between how we get the searches in. You know, we're getting it in for our purposes. Bank transfer fees out of the normal bank charges sort of regime, I think, are an expense. Accommodation, travel, all that kind of stuff. I would also argue medical reports, expenses, expenses of medical professionals. I'm thinking also counsel's opinions and advice. You know, this is all stuff that we feel, rightly or wrongly, that we need to buy in order to enable us to do a proper evaluation of the job the client's asked us to do. That's part of our services. We have to put VAT on all of that. The problem I think we've got is that we tend to call those things disbursements, which is a misuse of the term. So that's why I'm just leaving disbursements to one side for a moment. But these expenses, these things that we add to our bill in addition to our costs, have to have VAT on the total. And I think that seems to be undoubtedly the position that the tribunal was taking in Brabner's. A disbursement, on the other hand, is something which has nothing to do with us, effectively. We pay it because we've got the money to do so, but it's got nothing to do with us. Taxes, stamp duty, land tax, it's got nothing to do with us. It's just payable. Court fees, are payable, I would argue. Land registration fees are payable regardless. So they are technically disbursements. And of course, you wouldn't be charging VAT on those disbursements. I mean, charging tax on a tax is obviously pointless. But equally, if the client said to us at some point, oh, while you're on, do you sell widgets? No, I don't do widgets. Well, would you find me somebody who can sell me a widget? And we ask around and find a widget supplier. And he said, well, will you order me a widget? So we order the widget. The widget supplier supplies the client. We pay him the cash because we happen to be in possession of it. But it's got nothing to do with me. It's got nothing to do with the legal services I'm providing. It's entirely out with that relationship. That's a disbursement, and whether that has VAT on or not depends on the VAT status of the widget supplier. So I think that there's in the aftermath of Bradner's, there's a lot of clarification that we need to make in our minds as to what's an expense. Everything has to have VAT on it, and what is truly a disbursement, which may or may not have VAT on it, probably won't, in fact. And we need to separate them out in our bills as well. So you've got our fees, our expenses, VAT on the total, and then a separate item for disbursements underneath. And I think that's the better way forward. The problem, I think, for the profession generally is we tend to liberally call disbursements when in fact we mean expenses. Yeah. And that, I think, is the confusion.
Okay. We've just got time for a couple more questions, probably. So next one for you, Trevor. Can we really put our terms and conditions on our website and refer clients to them rather than sending out loads of paperwork?
Oh, I would love to think we could. I think, honestly, we can. Actually, terms and conditions apply seems to work for everybody else. So why can't it work for us? I think the SRA's view when they were coming up with the standards and regulations some years ago, when Crispin Passmore was still there, was very much to equate us with every other business provider, obviously subject to our additional, some fiduciary duties and, the utmost trust that clients put in us and that we mustn't in any way abuse. But in all other senses, why should we be penalised as business people for doing things in certain ways? And I think this whole notion of terms and conditions apply was tempting to me, and I've been saying for some years that sending the clients lengthy terms and conditions, lengthy client care letters, often supplemented with handouts about the legal ombudsman and everything else, and this sort of massive, great, thick wedge of paper landing on the client's doormat was counterproductive. I mean, the Law Society have said for a long time, that lengthy and tedious letters are often unhelpful, which I think is a neat way of putting the point. But nobody reads the damn things anyway. So I think sending this stuff to clients is a waste of paper, it's a waste of postage, and it doesn't do the job. I would much rather we put all of that standard stuff, which doesn't tend to change client to client, on the website, and just say to clients, look, terms and conditions apply, please see our website for details, with a link. And then they can go and read them if they want to. What we could then limit our correspondence to is the pure stuff which I am doing for you. You've instructed me on this matter in this way. I reckon it will take 6 weeks. I reckon it'll cost £2,500. And these are my contact details if you want any help or feedback. That's the only information you're really interested in. The rest of the stuff could go on the website. The other thing I want to say, though, is I want you to read it. And that's the problem. How on earth do I get you to have a look at the website and read it? And I'm just thinking, last time I got a mobile phone, I'm don't even know where it is now, but I was just going to hold it up. They did this to me, and they said, look, we need you to read our terms and conditions, so we're going to send it to you on the phone. Have a look at them, take as long as you like, we'll still be here, but just read them, and then when you've read them, just click on the bottom of the page and we'll send you the next page. So I got page 1 and I saw all the terms and conditions and clicked, yes, I accept. And I got page 2 and I read through page 2 and I ticked accept. And then I didn't bother reading pages 3, 4, 5, 6, 7, and 8. I just clicked the boxes and they said, okay, are you happy that you've read them then? And I said, of course I am, yes. Oh, good, we'll sign you up then on the terms that you've just read. And I wonder whether this isn't, it's a finesse, which obviously mobile phone companies can well afford, but law firms probably can't. But it was a neat way of tying me up to a set of terms and conditions. Whether I read them or not was entirely my choice, but they gave me the opportunity to read them before they signed me up. And that, I think, is the way we could be going. And I'm heartened to read in the latest SRA resources that there is something along those lines, which says that terms and conditions need not necessarily be included in client care letters. You can put them on the website and refer the clients to them if you wish. And by analogy, the SRA logo that we have to have on our websites, I mean, that contains a load of information about insurance and complaints and legal ombudsman information that we could refer the clients to instead of repeating all of that in the letters as well. So I think the SRA are giving us an opportunity just to be a little bit more light-hearted, if I can put it that way, with all of this information that we've currently been pumping out to clients, and they never read anyway, so it just strikes me as pointless to keep going. So I would think that should work, and clients of mine are indeed doing that. So I think we'll just have to wait and see what the SRA's reaction is to that. But it certainly seems to be possible, yes.
Okay, great, thank you. Right, this might be our last question. We've definitely got time for this one. So this one is: I've heard that the sanctions lists are changing when we finally sever our connections with the EU. Is that correct?
Yes. The sanctions lists are things which I was going to say the majority of law firms probably don't bother to think about. That may be an overstatement. And certainly I intend no disrespect to anybody tuned into this session. But sanctions lists are lists of organisations and individuals with whom it would be a criminal offence to have any financial dealings without or in breach of an appropriate Treasury licence. Now, at the moment, and this is going to be true until midnight on the 31st of December 2020, we have 3 lists. There is the United Nations sourced list, there's the European Union sourced list, and there is the UK sourced list of various organisations, individuals, all of whom are sanctioned. We've added a few of our own to the UN and EU lists latterly, in anticipation of us doing our own thing come January next year. Now, those lists are all on the Treasury website. The Office for Financial Sanctions Implementation lists all these things. As of the end of this year, when we leave the EU, apparently without a deal, but we'll have to see, the lists are going to go to 2 lists. The EU lists are going to cease to apply. We're going to have the UN lists that we need to observe and the UK lists, which I understand will comprise the existing EU lists, but obviously thereafter we can do our own thing with it. We might drop people, add people to it without reference to the EU. So instead of having to look at 3 lists, we'll only have to look at 2. But the net effect is much the same. We still have to look at the lists because there is no other way of checking these things. And we were talking about electronic searches earlier on. And of course, the theory is that the electronic search tools look at the sanctions lists and indicate to you whether these people are on it or not. But I mean, I can't speak for any of the search providers. I would hope those searches would be accurate, but you know, if all else fails, you just have to check it yourself, I suppose.
Yeah. Okay. I think we've just got time for one more question. Then this will be our final question. So our client who sold a property is now insisting that we send the balance of the proceeds to a bank account in the name of his ex-wife. Can we do this, or would it be in breach of the accounts rules?
My instant reaction is to say it would be a breach of the accounts rules. However, I suppose the other question is, well, I don't know the state of their divorce, and I don't know quite whether the ex-wife is also a client, if you know what I mean. But if they are both joint clients and they have both sold the property, and the deal between the two of them is that the balance of the proceeds go to the wife, and we can document all of that fairly comfortably, then I don't think there is too much of a problem. If, however, the ex-wife is truly ex, and he is selling his property, and she has no part in it, but he has decided to send the proceeds on to her bank account, then I would have thought that would have been provisionally a breach of the accounts rules, because Rule 3.3 says that we mustn't allow our client account to be used as a banking facility in any way, shape or form. And if they are truly unconnected, he is selling his property and it's his money, you know. And it's not part of the conveyancing transaction that we should send her the proceeds. You know, it's him. He can do with his own money what he likes, but we're acting for him. We've done the conveyancing work, and we owe him the money. And I think I would be inclined to say it would be a safer way, just to say to the client, look, I'm sorry, I'd love to help, but I can't. I'm a legal services provider. I've done the legal services, and I now have to account to you for the balance. That I think is the safer way forward.
Yeah. Okay, that's really great. Thank you. So unfortunately, that's all we've got time for today. Thank you for attending Law 2020 Online, Practice Management Shape the Debate, hosted by the Solicitors Group. Thank you to our expert speaker, Trevor. You've done a great job today. Don't forget to join the Solicitors Group Law 2020 Online community on LinkedIn to continue the debate after this live session and to be included in exclusive offers for future events. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within 48 hours. There is still time to watch Trevor's pre-recorded content, and the expiry date is displayed next to the webinar. Feedback forms for the event will be sent out when the event closes, and by completing this you will receive your CPD certificate. Please don't forget to visit the online exhibition at www.thesolicitorsgroup.co.uk, and by visiting the exhibition you can access a free 1-hour CPD webinar from the 2020 distance learning catalogue worth £35. I'll stay on, no I won't actually, because we are running out of time, so that's if we had more time. But thanks again, Trevor.
You're welcome. Thank you very much.
Everybody has a great day. Thank you.
Thank you. Yeah, goodbye.